Seated. The next matter to come before the court this morning is in re the matter of MP. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, if you want to let me know when you get started, I'm keeping the clock this morning. Court's read the briefs, we're ready to see when you are.
I'm ready, Your Honor.
I'm ready, Your Honor.
Good morning, Robert Cabrera on behalf of the natural mother in regards to this matter. Your Honor, I would like to reserve 3 minutes rebuttal. And likewise indicate a very brief recitation of the facts. The matter before this court is a Lorain County Children's Services motion for permanent custody that was granted by the court. Prior to the granting, of course, there had been adjudication of duties of elected dependent. That issue was already litigated, so the issue before the court was whether the mother failed to remedy the conditions that caused removal, and at some point that in the agency's view that she would not be able to do that, and sought permanent custody, and likewise the court granted that. Your Honor, my assignment of error indicates the constitutional implications in cases of this type. It's very customary for lawyers to argue that it's the equivalent of the death penalty case. There is a Supreme Court case that indicates that. I think in some ways it's unfortunate. It's not a death penalty case. No one is dead. No one will die. But there are many other constitutional implications. The due process requirement of the 14th Amendment, the First Amendment right of association, the right of privacy, the right to raise your child as, the right to raise your children as you see fit. The agency's obligation in a situation like this is to come in and sort of neutralize the situation. If a child is abused, neglected, dependent, place an individual, place the parties on a plan that would remedy those conditions and place that child back into that family situation. This case, in my view, based upon the circumstances, is a classic example of when that due process right is sort of overlooked. 18-year-old placed on a case plan that you could argue would not have necessarily led to the remedies which caused removal. The fact that the mother had accomplished many factors that were very important and were presented to the court, indicating that a clear and convincing standard of review would have required the court to determine that somehow that failure would never have, in my view, would never have accomplished the objectives of the agency. I don't believe that the evidence supports that position. In fact, the idea that extra time, the request of the mother for additional time to try and work with the agency, who had, without any question, even appeared and testified on her behalf, that took upon that challenge to assist this mother in that endeavor, and that it was likewise part of their function as a government agency to do, I think indicates the sort of overriding of that due process requirement.
What was the name of the agency again that she said?
The Urban.
The
Urban League.
And
National organization.
Sure. But what I guess I'm getting at is that was just a short time before the permanent custody.
Yeah, but Your Honor, I guess the situation, like in death penalty cases, the facts are always egregious. They don't come before the court unless they are. The facts in these type of cases, although not death penalty egregiousness, they are likewise. The agency would not have filed it if they didn't believe that the mother was capable of accomplishing the facts. In their view, that she's not. The agency typically would adjust that. In fact, the common practice is not to get the agency to file a motion for PC in the first place.
Well, and they had a voluntary case plan before they filed.
Of course.
Working with the family for a few months before they actually filed.
Of course, Your Honor, but I believe in this particular case, that case plan did not include the Urban League assistance.
Well, it didn't include mom having another child, too, during the course of the case.
I think in that way, that is a factor that, that makes the agency less likely to work. That I think sometimes they're offended for whatever reason. They look at now the additional burden of trying to raise a child and then how that impacts the mother's ability to perform when perhaps there was difficulty in accomplishing those facts in the first place. I'm still not sure how that impacts a constitutional determination and a due process type matter by the court. The court is obligated by clear and convincing evidence to meet that statutory obligation. And I don't believe that the court in this particular case does that. It's not a preponderance of the evidence. In fact, in constitutional interpretation, typically constitutional rights have to be a strict scrutiny. There has to be a limited obstacle, it has to be narrowly tailored to accomplish those facts. I think in many ways the clear and convincing gives it a buy. It's an intermediate level, but nevertheless it still requires some type of evidentiary basis. And in arguing on an appellate level, that is always difficult. It's not a question of whether there's a better way to do it or a least restrictive way to do it. It's a question of does this meet the constitutional requirements in order to accomplish federal or constitutional adjudication? And I don't believe that that's what we have here. Having someone come in and say, well, we think it's best if the child is adopted out, I don't think meets that level.
Well, that's not what they did here. I mean, the trial court found that there was a lack of commitment by the mother, that she had remedied the conditions that caused the child to be in the custody of the Children's Services Board. So why, in regard to those particular things, I mean, I know you're speaking generally of constitutional, and believe you me, I and the court take that very seriously with these type of cases. But nonetheless, the trial judge did find by clear and convincing evidence that there was a lack of commitment, that mom didn't have independent housing, that mom didn't visit with the child when she had the opportunity, a lot of different things that was going on there.
Yeah.
Counseling, the drug abuse.
I think the nexus would be that the mother was incapable of doing that, or that whatever reasons that it didn't occur, that the mother was incapable of accomplishing that. One of the requests by her counsel was that she be given an additional time, that the matter be continued for a period of time, allow her to work with the agency and demonstrate to the court that even though she may not have been able to accomplish them prior to that she would be able to accomplish that now, especially with the assistance of the agency. And they did in fact do that. Now I understand there's no requirement for the court to do that. There's no requirement that says that an agency gives the mother a lie. There's nothing, the court could easily turn around and say, well, you really should do it on your own. But each case, I believe, is individual. This was an 18-year-old mother. I think that has to be taken into consideration. Without arguing the case plan, it is possible she agreed to things that she probably could not have accomplished or would have been very difficult to accomplish. This court has addressed issues similar to that. Mothers or teenagers, juveniles that are placed on a case plan, having to go to school, having to work, having to accomplish all these things, and quite frankly, making the case plan almost impossible to fulfill. That's very similar to what we have here. No one challenges at trial the sufficiency of the requirements that are requested. It is just a given that she did not accomplish those. So now the issue has to be, was it fair? Was the case plan a fair case plan? Were the efforts fair were the assessments of her inability to meet those needs, assuming that they were? Was it a fair appraisal? And that again is a due process sort of consideration.
Well, wouldn't you agree though that the parental interests of the parental interests are subordinate to the child's interests when determining these types of cases?
Your Honor, I would love to answer that question absolutely, and I think the answer is yes, but nevertheless we're dealing with a constitutional adjudication, so there has to be some kind of leveraging back and forth. Of course, the children's best interests are paramount, but likewise it has to be juxtaposed against the mother's constitutional rights. This child was in foster care. This child's needs were being met on a daily basis. This child had no potential harm whatsoever. What was requested is that the child remain. No one was asking for the child to be removed from the situation the child was in. What the request was that allow this mother, young mother, despite whatever the court feels, an opportunity to demonstrate that she's capable of doing that, because ultimately that's what would be best for the child. I think, unfortunately, the determination is that the agency has a better outlook for the child, that for whatever, and I know it's actually not addressed, but one of the questions is adoption an option, and then would that be in the child's best interest? Never is there any evidence presented about adoption as to whether it works, whether it would work in this particular case, whether there's expert testimony. There's testimony provided by the caseworker that, yeah, adoption would be in the best interest of this child. And I'm just puzzled with the court's sort of acceptance of that. We wouldn't do that in almost any other type of case. Even probable cause, it has to be more likely than not. Clear and convincing has to be a much higher level than that. Beyond a reasonable doubt, that would never have worked. There was never any indication that beyond a reasonable doubt, this mother could not accomplish the facts that were presented to her.
But we're looking for stability for the child, and really that's paramount. We have, what, a 3 or 4 year old child that has spent 3 or 4 years with mom, sort of in upheaval, right? And we're looking to provide some stability for this child long term.
I purposely tried to avoid the fact that it was an 18-year-old. I don't believe that but I can't ignore the fact that it is. And myself as an 18-year-old, unfortunately, I shouldn't, but I think of myself as an 18-year-old or the 18-year-olds that I grew up with.
And there's no father here.
And the idea that a single mother, very young, having to accomplish this on her own with tremendous obstacles to overcome. And the truth of the matter is, if we said there was this person and there was that person, there's no indication that that person could have actually helped her accomplish that. In fact, my understanding is they had issues that they had difficulty with on their own. That agency, on the other hand, presented a different option. It's a professional organization. Granted, this may be a sort of a specialized plan or pilot program or what have you, but they did have federal funding and the money is available to do that. And there was a tremendous commitment, particularly by the caseworker that worked with the agency, who indicated even if the program wasn't refunded, she would still work with this individual to accomplish these needs. I think that is something that really needs to be addressed, and the court probably should have considered that more. The fact that if you do that on a due process or evaluation, what would have been the disadvantages of continuing the matter for 3 months or 4 months and determining the progress the mother would make during that period of time and then present a good picture to this court 3 months from now? Or
Counsel, you're just now reaching into that 3 minutes rebuttal time.
the other alternative would be 3 months later she doesn't successfully complete. I mean, sometimes you have to be careful what you ask for. Trial counsel to get up and say, Judge, give her 3 more months. I guarantee you she'll demonstrate to you she's capable of doing that. And 3 months later, it's not, and there's some issues, then yeah, you pretty much have just sunk your case. But this counsel felt confident that that was an appropriate alternative, and likewise the caseworker sort of corroborated that. And I believe that the court should have considered that compared to First Amendment, 14th Amendment, due process, constitutional adjudication, and I think her outcome would have been different. Anyway, thank you.
Morning, Your Honors. May it please the court, my name is Kara Finnegan. I'm the assistant prosecuting attorney representing Lorain County Children's Services in this matter. As Attorney Cabrera pointed out, permanent custody was granted of a minor child on September 22nd of 2014. And mother's initial argument is that the trial court's decision violated her due process rights. And while I wouldn't disagree that mother has a fundamental right to the care, custody, and management of her child, I don't believe that it's an absolute right. As one of your honors pointed out, it's balancing the child's best interest and welfare against mother's rights. And I will agree that the disposition of permanent custody is a very severe disposition, and that it is going to sever all parental rights. However, the courts have found that that is warranted when mother or any other parent has not demonstrated an ability to care for the child.
Do you think you should take into consideration the age of of the mother when you're establishing a case plan?
To some extent, I do. But I think the agency's position is always going to be what's in the best interest of the child. So,
Well, that you have an obligation to do a reasonable effort in order to reunify the family.
correct. So, and I think I think sometimes the best interest of a child is to be reunified with a parent, especially if there's a strong bond there. You know, considering the fact that the parent is able to provide for all those needs that the child has.
Isn't that what you start from the beginning with? I'm not sure I understand that comment. You have to, based on the fact that it is a fundamental right in the statutory framework, the first goal is reunification.
Correct, and that was
Unless there's a bypass, unless there's some type of interests that are like, you know, obviously abuse or something that, or a child has been removed previously from that home. So I'm not sure when you answer that sometimes it's in the best interest of the child. Isn't that the statutory framework until such time as it's demonstrated it's not?
correct. I guess to clarify, whenever you're beginning a case with a family, yes, it's always in the best interest to reunify and try and put in services in place for that family that's going to help correct any problems that the agency has identified or that parents have identified. So that's always the goal initially. And in this case, that's where we started. We didn't have a reason to bypass or anything like that. We did begin to work with Mother. And in this case, Mother had several services in place already. She was also working with the juvenile court, and there was almost a duplication of services there between what the probation department was offering, juvenile delinquency court was offering, and what children's services was attempting to offer. So I think initially there was a lot of support there to try and to get Mother to solve some of the problems that the agency identified as you know, being an issue for her to continue in her parental duties in regards to this child.
And how old was Mom when you first became involved with it?
18. She was 18 when we first became involved.
And that was a voluntary plan too?
We I believe there was some testimony that the agency had been working with this, had long-term involvement with this family. And in fact, there was some testimony that we were also working with maternal grandmother who provided a lot of the care for this minor child, especially when Mom was, you know, in pathways and in the detention home and things like that. So she, you know, there was a long history of working with the family. The agency was also working with maternal grandmother. And in fact, the reason for the emergency temporary custody that the agency sought on November 4th, November 4th, was that temporary custody of maternal grandmother's children had been granted to the agency on that day, and the agency had concerns about leaving the child in that home at that point.
So what I'm trying to piece together was, so Mom was less than 18 when you first started working with the family?
She was.
Okay, so she was a minor herself?
She was a minor herself initially when we started working with the family.
And you also had problems with maternal grandmother as well?
We did, correct.
And she was under a case plan?
Yes, she was as well.
I guess I'm just, you know, been involved in enough of these cases with Lorain County and different counties. And Lorain County has, I think, been one of the better ones in regard to doing fostering with a minor mother as well as a minor child. Was that looked into at all? Because obviously she wasn't getting the framework she needed or the assistance and support from maternal grandmother.
Just to clarify your question, you mean fostering the child with the actual mother? Yes, we did look into them. I guess some of the facts that maybe I should point out that Attorney Carrera didn't was that...
And obviously we just have to go what's in the record.
Right, is that, I do believe this was testified to, if I'm correct, is that there were several placements. She was initially placed with maternal grandmother, for most of her life. When the agency became involved, there was a short-term placement at Blessing House, there was a placement with maternal great aunt, and we did work with the family, and Mother was initially doing well, and we were confident in trying to do protective supervision and return the minor child to Mother to see how that worked and see if we could address those problems with Mother and child living together. The reason that actually led to the temporary custody was that there had been another domestic violence incident in the home that the agency hadn't been made aware of. We came to find that on our own, and at that point, due to the non-report and due to the nature of this domestic violence incident with children in the home, we sought temporary custody, not feeling that that would be a good idea, putting that child at risk to work a protective supervision case plan with the child in the home. So that's why we went with the temporary custody, which was granted on December 4th, and mother agreed to. And as I was saying, this, based on the fact of the severity of the disposition, mother had certain guarantees and she was afforded all those guarantees. At all times, she was afforded counsel. She was at most of the hearings, and the hearings that she wasn't present at, counsel did agree on her behalf by telephone consent. And she was also present for the permanent custody hearing. And going to the argument about the trial court's decision being against the manifest weight of the evidence, the agency presented, and the prosecutor's office presented evidence, the competent evidence going to each and every element of the permanent custody statute, which is a two-pronged test based on, in this case, whether or not the child could or should be placed with a parent within a reasonable time in best interest. And the one thing I would like to point out is Attorney Cabrera said that what was, and I don't recollect if this was necessarily testified to in this manner, but that it was said that mother could never work the case plan and could never reach the goals that the agency was asking her to reach. And I don't think that's certainly not the statutory standard, and it's not, I believe, what the agency was looking for. It was a reasonable time. What could she achieve in a reasonable time?
Well, I think what he's arguing is basically she was set up for failure. That, in other words, that you have a young woman that obviously the agency is aware of the fact that she doesn't have the parental support, and the agency was involved with her own mom. Had to take those children. In fact, she gives birth at 15, gives birth again at 18, and she's given a whole list of things she has to do that would be daunting for any one of us to do, let alone a young, unsupported minor mom.
Mm-hmm. And I do understand that concern. However, I know that there is other case law where there's been minor mothers who've been expected to do similar things, similar things that are in this case plan. And I think when it came down to mother's attorney asking for an extension of time, it was not necessarily that the agency wasn't willing to continue to work with mother. The problem came down to that mother had made almost no progress on her case plan. And I do believe that given some improvement in some areas, showing some satisfaction of addressing those concerns, would have led the agency to actually extend time and look for an extension of temporary custody. However, by the time we got to the filing for permanent custody, mother hadn't addressed any concerns about mental health. She's not engaged in mental health treatment. She did have diagnoses. She was not engaged in substance abuse. And in regards to the additional child, I don't know so much that it was the additional child that pushed the agency to file for PC. I think it was the fact that that child was positive for marijuana, and that mother continued to test positive for marijuana and had refused residential treatment. And she also was considered to be homeless at the time. She'd actually been homeless. The caseworker had knowledge since about October of 2013. So I think the issue was not only was she not making progress, but she was failing to connect with the caseworker who was trying to offer her support. So I think in cases like this, we would very much try to address a younger client, a younger mother, who obviously does not have the support system. But I think in a case where we can't connect with her, she's not connecting with us, she's not engaging in any of the cases.
What about her involvement with Urban League?
The involvement with Urban League came in, I believe, August. We had filed for permanent custody in June. So this was came on for hearing September 22nd. So she had worked very briefly with Urban League. We didn't have a lot of information from her caseworker. I think the caseworker had contacted the agency once. And again, it was a little bit of duplication of services at that point. She was, again, just in the beginning stages of everything we'd already asked her to do and attempted to facilitate for her. Again, being in the initial stages of a drug and alcohol assessment, which he'd already done through the delinquency court and through children's services. We made referrals and tried to get her residential bed at Locata. She had, runs big, I don't exactly recall, but I know she would have had to do another assessment for mental health. And she was in the beginning stages again of applying for LMHA housing, things of that need. The caseworker from the Urban League, in fact, testified at the hearing that she would still consider her to be homeless. So I think at that point it was a little bit too late. There was no real engagement there, although she had started, given the fact that she'd not followed through with delinquency court and her probation officer, given the fact that she'd not followed through with us, given the fact that this had happened so close to the PC hearing and not even, towards the filing, it was after the filing, that we did not have faith that the agency was going to be able to address within a reasonable time the concerns that we had and be able to restore her to the ability to maintain her parental duties. So I think that was the concern with Urban League, was that here we were again at a starting point and we had no real track record just to believe that she was going to follow through, nor did we have any concrete information that she was engaging in services through them. It was all beginning stages again. So, and I know the argument has been that, the child was in a foster home and that her needs are being met and there was no potential harm. But I don't believe the agency saw it that way. Here we were working 6 months at least 6 months with a court-ordered case plan. We'd seen no improvement, no changes, no engagement in services. We had 2 foster placements for this minor child. She was, initially in one foster home, moved to a foster home to be with her younger brother, and was doing very well there. She was no longer eligible for SSI because she was making such great strides in her speech. Her behavior had become better. She was referring to the foster mom as mommy. She was happy with her little brother. So I think there is harm there in giving an extension of time where this child is already...
Just out of curiosity.
Yes.
How does that happen? Why is a child referring to a foster parent as mommy when they have a biological parent?
I guess I don't understand. I couldn't give you the background on having an expertise in that.
Well, I just was curious over that because.
But I think she was very comfortable there. She was, as the GAL testified, making very great strides, and they were working on her with behavior. They were working on her with speech. So I think she came to feel stable in that home and comfortable, and I assume would have considered that her home, although I can't point to any testimony that said that. But I think the fact that she was becoming very bonded with that family, to then, 6 months down the road, a year down the road, mom does, make some progress, and we pull her out of that placement. I think that's very confusing to the child at that
Well,
point.
that would be the case in many. Let's say she was making all kind of progress and you gave a 6-month extension. And the goal is reunification with the biological parent initially. I'm not sure about that argument because obviously it would be confusing to the child, especially if the child is not told this is not your mother, you still have a mother, those type of things. So I'm not sure that really enters into the equation, does it? I'm sure it was very confusing to the child and disruptive to be taken away from the biological parent as well.
I would agree with that. I guess the one thing I would point out here that would, I think, alleviate some of that confusion and concern in other cases is that we didn't even really have consistent visitation here. So she wasn't even consistently seeing mom. Mom had 42 opportunities to visit. She only exercised 12 of those. So, now I guess the concern is where is that bond between mother and child? It seems to have deteriorated. So I can see if maybe, we're doing a reunification case plan, the child is consistently seeing mother, still refers to mom as mommy, and is seeing that, relationship progress as mom makes progress. But here that wasn't the case. The child wasn't even having consistent visitation. So I think that equals into my equation of, confusion and need for permanency for this child, that she really was lacking that bond with mother by that point. So.
And counsel, you have your standard here a lot of time.
Thank you, Your Honors.
Counsel, you have 2 minutes remaining.
2, Your Honor?
Yes.
Okay, I took one, I thought,
I'm going to jump right in. What about that last comment she made? She says the bond is basically gone because mom demonstrated a lack of commitment by not visiting and not being part of her child's life when she had the opportunity.
number one, these cases are never perfect. If they were, they wouldn't have filed them. The truth of the matter is, and there's never enough evidence presented to the trial court, that the agencies have visits at the agency from 8:30 to 4:30 Monday through Friday. Nowhere do they allow the mother to visit with the foster parents. It's always at the agency. So 42 visits were arranged at the agency, which means the mother had to be there between 8:30 and 4:30 Monday through Friday. Arranged for her own transportation, arranged for her own. That's essentially what happens in these
Well,
cases.
wasn't it really just like for maybe a couple hours, one of those days?
So, sure, they have a little room and they allow them to go in and they visit. It's almost like they come back and say, mother was asked to get housing, she wasn't able to get housing. This is an 18-year-old. The agency was involved with this mother from the age of 14, I believe, when she had this child. 14 or 15, it's a little bit fuzzy. But she was a minor of a very young age when she had this child. She was on probation to the juvenile court. The court, you heard the state mention that. I'm not sure how that's relevant to the court's determination about juvenile and being able to comply with their juvenile orders. But in my view, since it's been brought up, that's an additional hurdle for this mother to overcome. Then they want her to get individual housing. There's only one way. She has no employment. She was homeless. In some ways, the agency helped her to become homeless. LMHA, it had to be Section 8 housing. There was no evidence to the fact, but how difficult is it to get metropolitan housing? Did the agency assist her in that? The agency made a referral to an agency that would assist in that. What if the waiting list was 6 months? What if the waiting list was 9 months? How did the agency respond to that? I'll go one step further. On the day that she had complied with everything that the agency wanted her to do, because part of what they wanted her to do was to give her the name of the father. To this day, they don't have the name of the father. How that would have remedied the condition that caused removal, I don't know.
Well,
Would have made it.
wouldn't that have been another resource for this child? If the father were a viable placement, she'd be able to maintain contact with this child forever.
Without any question, Judge. And in fact, that's the point is everything the agency does have a rational basis to it. The question is, and we've never argued that these cases there's an absolute right. There's never an absolute right in First Amendment adjudication. You can't yell, panic, or fire in a crowded room. There are always restrictions. It's the balancing. And taking a 14-year-old girl in the system who has a child when she turns 18 and then taking a juvenile and imposing on her, and without any question, she is now an adult and she now has a child, imposing on her all those obligations and procedural requirements, and then coming back at a later time and saying you failed at meeting those obligations, I think was unfair. And I think it is at least a legitimate concern for the court to consider. And that's what I would ask.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the House Supreme Court website.
Thank you.
Thank you.